What is one of the biggest misconceptions about settlement discussions in a civil lawsuit involving medical malpractice, accidents, or wrongful death? Would you like to know the answer? Come join me for a walk around the lake as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The moment we get a call from the defense to say that they would like to start negotiating during the course of your lawsuit, and now we call you up to tell you that the defense would like to start negotiating, now in your mind you believe that they recognize that they did something wrong, and that would be accurate. You believe in your mind that they recognize that your injuries are so significant and permanent and disabling, and you feel that they're going to give you every single dime. Why? Because they recognize that they were wrong. That's the misperception that many injured patients and many injured victims have when they're told that settlement discussions are going to start. Why? I'll tell you why that happens. Most injured patients and injured victims believe that when the defense comes and they recognizes, it's almost like they're capitulating. They're recognizing, okay, you're right. Oginski, your client is absolutely right. We screwed up. We did something wrong. And now let's bow down. And yes, whatever you want is yours. Well, that would be nice if it were true, but that's not true. And that's not how it works. You should know that in these, let's say, medical malpractice cases, we are required to show that we are slightly more likely right than wrong than what you are claiming is true. We have to show that in a malpractice case, the doctor was careless, that he violated the basic standards of medical care. We have to show that that carelessness was a cause, it doesn't have to be the cause, of your injuries, and we have to show that your injuries are significant and or permanent. All of those things have to be confirmed by a medical expert who has reviewed all of your records and confirms each of those things. Now, the defense at some point during the course of your lawsuit against a careless doctor or careless hospital staff may come to us and say, hey, Gerry, listen, we've had the case reviewed by our own experts who feel that, we're going to have a tough time showing that we were not liable, that we did not do something wrong. Now, based upon that expert review or those experts who have reviewed the case, we'd like to try and start talking. So now I said, fine, make me an offer. Now, when they come back with an offer, and I call you up to tell you about the offer, you know what happens typically? How could they do that? That's outrageous. That's an insulting offer. Well, two things just happened. Number one, they gave their first lowball offer. Number two, you are outraged. You can't believe in your heart of hearts that they offered such a low amount. And you can't understand why they would do that when they know that they did something wrong. So you, as the injured patient, as the injured victim, you are focusing solely on what was done wrong to try and equate that to how much money they are going to offer you. And there's the disconnect. That's the problem. That's the disconnect. That's the misperception and misconception that many injured patients have when settlement discussions start. Now, how do I know this? I know this because when we start to talk about the value of your case, you, the injured patient, oftentimes will turn around and say, yes, but I know that the doctor did something wrong, and the defense recognizes that they did something wrong, and it was so terrible that they missed this. It was terrible that they didn't do X, Y, and Z. And you know what? As I said before, you are absolutely correct. They now recognize that they were liable. They now recognize that they did not adhere to the standards of good and accepted medical care. Here's where the problem comes in. You believe that because the doctor was careless and caused you harm and injury, because of how outrageous that act was, you now believe you are entitled to X amount of money. The reality is, in all likelihood, you are entitled to receive money as a form of compensation for all of the harms and losses and damages you incur. Just because the defense comes to us and says, look, we can't defend this case, we would like to start negotiating, that does not mean by any means that they recognize and acknowledge the extent and the severity of your injuries and the extent of your damages. I will tell you, they will fight us tooth and nail to show that your injuries are not as bad as you claim them to be. And again, you come back to me and say, but wait a second, the doctor was so wrong, he never should have done all those things. And the reality is, yes, that is true. But when we talk negotiation, when we talk money, when we talk settlement, now we are way past the first two questions about whether or not the doctor was careless and whether or not that carelessness was a cause of your injury. We no longer have to discuss that. That is a given. Once settlement discussions start, we no longer focus on what was done wrong, and we no longer focus on how that wrongdoing caused you harm and injury. Instead, the focus turns to damages. What is the extent of your injury? How disabled are you? What are you no longer able to do? How are you limited from doing your daily activities? What permanent limitations and restrictions will you have going forward into the foreseeable future? Once we are able to document and to show the defense that your injuries truly are more significant than they perceive it to be, now we are in a much better position and have a much stronger negotiating position, because now they see that you have gone to many, many doctors to try and obtain treatment for all the problems you're experiencing, that it's clear that you will need ongoing therapy for the rest of your life, that you will need corrective surgery, that you will need the following care and treatment for the foreseeable future for many, many years. Once they understand that and recognize the extent of your damages, now everybody focuses on the value of your injuries, and they will look at many different factors to evaluate the value. And isn't it interesting? In practically every single case where negotiations take place, the defense has a different point of view and a different perception of the true value of your injuries compared to our assessment, meaning the plaintiff's assessment of your injuries. We value it much higher, the defense values it much lower. And the question is, can we reach an agreement and negotiate to establish a number that we can live with and that the defense can live with? If the answer is no, then we will go to trial. And even though the defense has recognized that they cannot defend this case, we may have to have a trial simply to determine damages, where 6 members of the community will now be charged with determining how much money you ought to receive for your pain and suffering, where 6 members of the community who don't know you and don't know the doctors involved will have to determine what other damages you are likely to experience, your medical costs, your lost earnings, your pain and suffering into the future, among others. So why do I share this quick information with you? I share it with you to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I recognize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.